Show. Turn up your mind.
Republicans have a scheme that could remove American voters from the process of selecting their next president. You heard that right. A case headed to the Supreme Court could let Republican-controlled state legislatures overrule the will of the people and pick the next president of the United States without you. This all hinges on a radical idea called the Independent State Legislature theory. It's at the heart of a case the Supreme Court will decide called Moore versus Harper. The decision in this case could give state legislatures the power to disregard the popular vote and substitute their own slate of electors, pledged to whomever they wish. We've already had a preview of what this could mean for our democracy. The Independent State Legislature theory underpinned a major legal strategy in Trump's attempted coup.
Just look at one thing. The legislatures of the states did not approve all of the things that were done for those elections. And under the Constitution of the United States, they have to do that.
Trump was wrong, of course, but the current Supreme Court could make him right. Here's background on the case. In February 2022, the North Carolina Supreme Court blocked the state's Republican-controlled General Assembly from instituting a newly drawn congressional district map, holding that the map violated the state constitutional ban on partisan gerrymandering. The Republican Speaker of the North Carolina House appealed the decision to the U.S. Supreme Court, advancing this theory, a theory that's circulated for years in right-wing circles, which argues that the U.S. Constitution gives state legislatures alone the power to regulate federal elections in their states. Now, the Constitution does grant state legislatures the authority to prescribe the times, places, and manner of holding elections. But the U.S. Constitution does not give state legislatures total power over our democracy. In fact, for the last century, the Supreme Court has repeatedly rejected the independent state legislature theory. Yet if we know anything about the conservative majority that now controls the Supreme Court, it's that they will rule on just about anything that suits the far right's agenda. The theory would also make it easier for states to pull all sorts of election trickery, like pass even more extreme voter suppression laws, enact even more radically gerrymandered maps, and eliminate the power of election commissions and secretaries of state to make decisions altogether. It's bad enough without the full protections of the Voting Rights Act. The last thing we need is for voter suppression to be made even easier for extremist state legislatures.
And that is what is being argued today at the United States Supreme Court, the Independent State Legislature theory. I mean, the proponents of the strongest form of the Independent State Legislature theory say that means that there is no other institution or organ of state government that can do anything once the state legislature passes a law having to do with voting. The state courts can't review it. The governor can't veto it. You couldn't have an independent commission to draw the maps that are rejected by state courts. And the state court then says, you know, we need a special master in the case of New York, or we need an independent commission in the case of Michigan, to draw a free and fair map that represents the people in the state rather than the state legislature's party preferences. So this is what's being argued in the Supreme Court today, and the caller that just called us has every right to be incensed, alarmed, and outraged that the Supreme Court even took this case, unless the Supreme Court took this case, because this is also a manufactured case, meaning the Speaker of the House of the state legislature in North Carolina is the Moore in Moore v. Harper, right? That's Tim Moore. He is the Speaker of the House of North Carolina. And he and his legislature, which are obviously Republicans, drew these maps. And the maps were deemed by the state court to be very partisan in nature and were designed to dilute the voices of anybody other than Republicans in that state. And therefore, a special master had to be appointed in order to redraw those maps. Well, Mr. Moore was so incensed that he petitioned the Supreme Court, went straight to the Supreme Court, didn't bother to go anywhere else, okay? Not to a state court, not to the state Supreme Court, not to a district court, not to a appeals court if he got a decision he didn't like. No, he didn't go through any of those processes that we think we're familiar with in order to get to the Supreme Court. There's no dispute in lower courts, which is what we typically think the Supreme Court is there to decide between when courts disagree with each other. That's not even present here. Obviously, it wasn't present in the web designer case either. Nor did she even have a business. She has a proposed business, and she wanted a preemptive ruling. There is no there's no injured party in the web designer's case, and there is no complaint against her. There is no dispute in the courts because she didn't go to any other courts to have them wait. Well, that's not true. There was a lower court that disagreed with her. Okay, and she went straight to the Supremes. But this case is manufactured as well. And this case is asking the Supreme Court to rule that state legislatures are the arbiters of all election regulations, all election laws. State constitutions be damned. They don't matter. And there's no judicial review in a state court for any aggrieved party who, wants to bring a case. None. There is no role for any other organ of government in your state to play once the legislature decides it wants to ignore your constitution, your state constitution. And every state has a constitution, a state constitution. So that is basically what's at stake here today. And it's huge. It's enormous. It is a game changer. It would change everything, okay, whether or not to adopt a legal theory that would radically alter the way we vote and if we vote. Because remember, the strict reading of the Constitution, not the intent of the framers, which is a different thing. Because when the framers wrote the words that said that it's called the Elections Clause, and when the Constitution wrote that the legislature of the states should set the times, places, and manner of holding elections for senators and representatives, that it would be prescribed in each state by the legislature thereof. There were no state constitutions, okay? We didn't have, state courts. There was a whole apparatus that didn't even exist, okay? Obviously.